rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. We are here for oral argument in case number CV21-0732 in the matter of Peter C. Warner versus Kimberly Driggs Warner. Each side, first of all, counsel, these proceedings are being video and audio recorded. So we ask counsel to please identify yourself and your client before beginning your argument. Also, each side will have 20 minutes, and appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if so desired. We have read the briefs and we have discussed this case at conference. So with that, counsel, you may proceed.
Good morning. May it please the court. My name is Marlene Parntrelli, and I'm here on behalf of the petitioner and appellant Peter Warner. I'm here with my colleague, Alex Crandall. I would like to reserve some time, and I'll try to watch the clock to make sure I do that. There are a number of issues in this case that are covered in the briefs, and we believe are addressed in our reply brief. But for purposes of oral argument, since I won't have time to address them all, I would like to emphasize 4 items. The first being the division of husband's separate property in the Roth IRA 3012 and the rollover IRA 3019 account. The second one being the $45,000 in income that was attributed to father, which then resulted in a child support award and a spousal maintenance award, as well as attorney's fees when that income is all fictitious income. 3, the award of attorney's fees based on that disparity of income. Also, the court indicating that father had violated the preliminary injunction when he had not, and also identifying an unstated false claim, which the parties have interpreted as being that he changed his pretrial statement and that was a violation of Rule 69. And then finally, the 529 plan, where the documentary evidence that was presented shows it was funded with $50,000 from father's separate funds and $50,000 from community funds, with an intent by both parties to fund the children's college education.
So you're not going to address preclusion today?
Preclusion in terms of what, Your Honor?
The court's order precluding late disclosed evidence.
Yes, Your Honor, that's actually the very first issue. Okay. And so it is of primary importance here because it's the Roth IRA 3012 and the rollover 3019 account, which the primary issues with respect to the reason why the court erred in dividing separate property is the court excluded the expert and documents based on the plain language of the order that provided for a deadline of July 2nd. It provided...
Let me throw you a softball.
Okay.
If, leaving aside all the preclusion, assuming the preclusion is affirmed, my understanding is that the separate nature of some of the property that went into the accounts you're discussing is revealed in Exhibit 30, which was admitted. So why do you need to hang your hat on getting in evidence that was precluded for late disclosure?
And Your Honor, that was actually one of my very first points here too, is that the court had the evidence before it. They had not only the testimony of husband, but they had Exhibit 30, which was 230 pages that was divided up into separate exhibits that had all of the documentation. In addition to that, the court had a demonstrative evidence, Exhibit 29, which was also admitted into evidence as a demonstrative chart. And so you have husband's testimony, you have the demonstrative chart of Exhibit 29, and you have all of the backup documentation that clearly shows all of the tracing that husband had done to indicate that there were substantial separate property in both the 3012 account and the 3019 account.
So you don't need the late disclosed information, according to you.
According to us, Your Honor. That's one of the primary reasons why we think that the court erred. In addition to that, we think there are other additional errors that the court did, because if for any reason the court felt that it should have, that they couldn't couldn't prove that, or the court didn't want to look through 238 documents to verify that what husband was testifying to and the chart was correct. What we think should have been done is what was done in the Nitsch versus Clavin case, which is a memo decision, but it was one that came out actually the very day of trial, and we submitted as a post-trial memorandum, where in that case the court basically said, I can't tell how much of that is separate and how much of it is community, and neither party is giving me enough evidence. So I'm going to submit it to an appointed special master, a retirement specialist, which the court can do under the Arizona Rules of Family Law Procedure 72 and 72.1. And in that case, we'll let the retirement specialist make that determination. That is exactly what father asked for, both in conversations with Respondents' Counsel, asked for it in the pretrial statement, asked for it at trial, and asked for it after trial. So if the court was not going to do the work to look at the demonstrative chart and also look at exhibit number 30, the easiest thing for the court to have done at that case is say, let's send this over to a special master in light of the fact that retirement accounts can't be divided until after the decree is entered anyway.
Well, that's kind of why we tightened up on the rules, on Rules 72 and 74, as the courts were doing the easy thing too often. I don't think we, as an appellate court, should be in the business of directing courts to appoint special masters. It may be that the court could have gone that route, but I don't think it's its duty, and I don't think we could ever say you abuse your discretion by not appointing a special master. What we could conceivably say is there was enough evidence admitted that you need to take a harder look, court. But are you arguing somehow that we have the ability to compel appointment of a special master?
No, Your Honor, but I am arguing that it was an abuse of discretion for the court not to do that in light of the fact that you had Exhibit 29, you had Exhibit number 30, you had testimony from husband, you had no testimony from wife other than, well, I think these accounts were created during the marriage, which husband doesn't deny, so that's an undisputed fact. They were created during the marriage, but they were rollovers from previous retirement accounts. So he had profit-sharing plan, he had a money purchase plan, he had 401ks, and they were rolled over into these IRAs once he retired. So technically, yes, those IRAs are created during the marriage. That was the only testimony that wife had provided. Yet husband provides all of that documentation saying, there was one deposit made in one account, and I'm getting penalized for that when this is exactly what retirement specialists do. So, Your Honor, which is what we had said at trial, if you don't think you have sufficient evidence, we think you do, you have the option then to also appoint a special master. So not compelling the court to do so, but if the court is saying, I don't want to look at this evidence, and I don't want to do this, I want to send it to the retirement specialist, the court could have done that. It is a snowball effect, though, because it really started with the court misreading its own order, which specifically says both parties shall complete all disclosure requirements. No, it doesn't say all disclosure and discovery requirements. It says complete all disclosure requirements required by Rules 49, including an exchange of all relevant information, documents, and exhibits at least 30 days prior to trial, unless, in the very same sentence, the court sets another discovery deadline. And that is all one sentence that defines disclosure as being modified by what the discovery deadline is.
You know, it reads to me a lot like a little boilerplate minute entry. I'm not even sure how carefully the court considered it, but no matter how aggressively you can argue for the interpretation of that, if we adopted your position, we would be endorsing an initial disclosure one day before the close of discovery and basically then reading discovery out of the rules.
Your Honor, I don't really think that's the case. Because
what were they supposed to do on July 1st? They get this dump of 1,000 pages. Are they supposed to notice depositions for July 2nd?
And, Your Honor, that is the problem with having collapsed this into one date. But husbands shouldn't be penalized for that.
Who should?
Because
wife?
No, what could have
wife
happened.
doesn't get discovery, right?
But, Your Honor, let me give you a hypothetical that illustrates why the court's order is written the way that it is and why it should be interpreted the way husband is. Everyone would agree, including wife, that if we had sent out a subpoena and we got our documents responded to on July 2nd, that that's within the discovery deadline. No dispute as to that. Now, let's assume those discovery documents that we get have bank accounts listed and documentation that we just go, boy, are we so glad we got this. This is exactly what we needed for court, and we're going to submit in this whole response. According to wife's interpretation, you can't use that document anymore at trial because the disclosure should have been 30 days ahead of time.
That interpretation would be wrong, too. But the interpretation that says we can lay an expert report on you one day before the close of discovery strikes me as really unsustainable.
But, Your Honor, that's the ambiguity then that is created in the order itself.
So what's your responsibility then, not you personally, but what is the responsibility of your side when confronted with an order like that? Just to try and backload all disclosures to the last minute, even expert disclosures which are well within your control?
No.
That doesn't seem to me to be a fair-minded interpretation of the order, even if the order is defective.
And Your Honor, though, that defect, though, shouldn't go against husband in this case.
Who should it go against?
Then if anyone feels they are prejudiced, then they could have done what had been done previously in response to the previous court order, which is either the parties stipulated, which they did do in that case, they stipulated to when the depositions had to be taken, or they continued trial, which is exactly what we had requested when we stepped in, because we said, there aren't any experts here. We said in our motion to continue the trial, we're coming into this case, but we're not going to come into this case unless the trial gets postponed, because we've noticed there haven't been any experts designated in this case, and we're going to want to designate at least one expert.
And we'll do it on the very last day, so there's no chance for any deposition of that expert.
But the court could have remedied that, Your Honor.
But the court didn't. Let's assume the court made a mistake. The court's order wasn't great. I will agree with you. It didn't lay out a rational progression of disclosure and discovery. It doesn't fall to your client to take advantage of that and use it for an unfair tactical purpose, because that's the one thing you know the court didn't intend.
Well, Your Honor, I don't think he was using it as a tactical advantage. First of all, and let me tell you exactly why, in this specific case, and the facts demonstrate this because it's in the record, we first indicated back in May that we intended to hire an expert when we brought our motion to continue. In June, and this is in response, June 21st, in response to the motion in limine, we say we intend to retain Deborah Hunter to do all of this tracing if we can't come to some agreement as to what should happen. Remember, husband's thinking the easiest thing to do is let's just give it to, like we do in a lot of divorces, give the retirement accounts to a specialist. We don't even have to have a trial on this issue. But if you're insisting on a trial, then we're going to hire Deborah Hunter. So they are aware of that. We provide her documentation according to the court's order. That's a plain reading of the order on July 2nd. If they thought that that is not going to give them sufficient time to be able to depose Deborah Hunter if they want to do that, in order to cross-examine her if they wanted to do that, their obligation is to call me and say, can we continue trial? And you know why they don't want to do it? Because they want to take advantage of this procedural inconsistency that's in the order and want to force it. Because the court originally, when they were granting the motion to continue, wanted to set the trial in January of 2022. Wife didn't want that. Wife wanted the soonest date possible. So what happened was that trial got continued with less than 49 days. So there was no possibility at that point to comply with a 60-day requirement for the designation of the expert, because the court set it at 49. But we felt some comfort in all of that, because in reading the order, it says a date. And it's like, okay, we'll do it by this date. And if one party feels they're prejudiced by that because you complied with the date, then the obligation is ask for a continuance or ask for a continuance of the discovery deadline, which is exactly what the court says in its order, the parties can stipulate to that. So,
But counsel, that takes us back to Judge Swan's initial question, or the discussion you had with him initially. How is Father prejudiced by the preclusion of this evidence when Exhibit 30, Exhibit 29 provides the documentation necessary to support his position?
and if the court had relied upon it and used it, then they wouldn't necessarily be, but the court didn't do that.
So
The
that's
court
really the
ignored
error you're arguing here.
That is one of the errors. We just believe that it's kind of a snowball of effect of errors, because the court also didn't allow demonstrative exhibits in simply because they said, well, you didn't prepare them yourselves, which no case says that the witness has to prepare them themselves. The chart can be Microsoft does charts all the time. We just print them out and they come out into this nice Excel spread worksheet. It doesn't mean that Father hadn't given the information to create that chart, but that was another error too, and it didn't allow for Father to refresh his recollection to be able to get up on the stand and testify. So when you look at all of those errors with respect to the preclusion, I think you start with the notion that the court had the documentation before them. They had it in the form of Exhibit 30 and Exhibit 29. The court didn't rely on it, and the court didn't even review it or make mention of it. The second part is that Father did his best in complying with what the court order said. He had provided information way back when he brought his first motion to continue, saying, I want to hire an expert. On June 21st, he identified who that expert was and said, here's the tracing that's going to be done. Unless we can come to some agreement, that's all in response to our motion in limine. And then on top of all of that, when we do disclose it, now we're told at trial, you can't use your expert, you can't use the demonstrative charts, and we're not even going to give you now more time when you find out that you're running out of time. All of that, then asking on top of that, then if this is what we're going to do, compact all of these complicated issues into a one-day trial, please send this retirement account so that we don't get into the problem of dividing separate funds that are improper to divide anyway. Instead, we'll have somebody looking at it and dividing just the community portion, which is the fair and equitable thing. I see I only have 3.5 minutes left, so I'll save it for rebuttal.
All right, thank you, counsel.
Good morning, Your Honors. I'm Mark DePasquale, and with me is Paul Schmidt at the council table. We represent Kimberly Driggs Warner, who is present in the courtroom. We are asking the court to affirm the family court's decree in this case and to award attorney's fees to our client on appeal. For the sake of simplicity in this argument, I'll refer to our client as wife and to the appellant as husband. I'd like to address two main areas, and I think in doing that, we'll cover some of the issues that were raised in the questions that the court asked. The first is the exclusion of the untimely evidence, the untimely disclosed evidence. And the second is rulings on the court's designation of the accounts as either community or separate, because in our position, Your Honor, is that Exhibit 30 and the exhibits that are shown there do not support husband's claim for separate property.
Maybe you should move to that right away, given how many issues are in the case.
Okay, thank you, Your Honor. So there were 5 issues, five accounts that the court had to deal with tracing. 3 were husband's accounts and 2 were wife's accounts. And all of those accounts were initiated during the marriage. So in each case, the parties had to show by clear and convincing evidence that they were separate property.
Well, in the case of, and I hope I don't get these numbers wrong, but in the case of 3012 and 3019, Is it not the case that we have pretty incontrovertible evidence that something over $100,000 existed before the marriage and wound up in those accounts?
Yes, Your Honor, I would say that, yes.
Knowing that, and knowing that this wasn't a daily checking account with thousands of transactions over the course of the marriage, wasn't it incumbent on the Superior Court to perform some tracing analysis? I mean, there was clearly a separate contribution, and it was given no weight. Isn't that problematic?
Your Honor, I respectfully disagree with
Go ahead.
with what the trial court did there. I think there definitely was an investigation by the court into tracing. The court set forth all the different accounts that these funds, according to husband, had gone through in order to get to the 30. I'm sorry, was it 3019 you're talking about?
I think we're talking about 3019.
But in both cases, that was the case. In those cases, there was not, well, let me step back and say, explicit tracing is what's required by Arizona law in order to establish separate property. And that can be established by direct evidence, which is the account statements showing a link, the account statements all the way through, or in the case where those aren't available or destroyed or whatever, if by testimony, as long as that testimony is clear and convincing.
Well, don't we have statement-based evidence of at least one premarital account containing somewhere around $115,000, and then statement evidence of that $115,000 winding up in one of these accounts?
Well, we have those amounts, but I would submit that we don't know that's the same $115,000 that got there.
It's a heck of a coincidence.
Well, it may be, but what the court looks at is show us the documentary evidence, because you either have to show it by specific documents, and in this case, the husband didn't do that. He put forth just 2 or 3 statements, one from many years ago, and one somewhere in, I think it was 2012, and then another one later on, and then tried to establish through his testimony that this was all the same amount.
I guess my concern is not that we can sit here today and decide what's community and what's separate. My concern is that the court below didn't do enough to make that determination itself.
Well, I'm not sure what else the court could have done, Your Honor. The court listened to the testimony. The court
could have said, hey, there's $115,000 existing before the marriage that wound up in this account. Maybe we shouldn't count that as community. Right? The court could have done that. The court even then could have gotten more sophisticated and looked at the growth in the account and those sorts of things. But at least the principal deposit that was sole and separate should be given some credit, shouldn't it?
But we don't know, Your Honor, we don't know that the initial deposit into the account that we're talking about now, that's what we're trying to determine whether that was separate or community.
Well, it was in 1999 that it existed, so it was by definition separate.
No, Your Honor,
Is that wrong?
I believe that's incorrect. I believe that all of these accounts were formed after the marriage.
Well, the accounts that exist now were formed. But
yes.
what I'm referring to is, okay, I've got the number now, $107,447.93 in a Smith-Barney IRA existing before the marriage. That amount, we don't have a detailed record of statements, but that amount winds up in an account, I believe, called, well, I think it's a 3019 account, the Just 2 Trade account. Right? And if we have documentary evidence that money existed in the Smith-Barney account before the marriage, that's an issue we cannot avoid, or the trial court cannot avoid.
Well, but the trial court could not avoid it, Your Honor, if you could show the link between all these accounts, because it started in one account and then moved to another and then moved to another. And if there was evidence that showed this is the same amount, then yes, you're right. The court would have to take into account that there's direct written evidence that this is the same $100,000 that started in that account ended up in the community account, but that's not what happened.
Well, on Exhibit 30, we have a deposit made in that amount in December 2012, right? And, I mean, we have some evidence that it's there. Now, I'm not suggesting that supports any sort of conclusive determination. I'm just concerned that the trial court didn't seem to give it any consideration at all. It just threw up its hand and said, well, it must all be community. I don't know that that's sufficient.
Well, I think I don't think that's what the court did. I think Your Honor would be correct if that's what the court did. But when in fact the court did was looked at the lack of documentary evidence and said, all right, you've shown me over the course of the last 20 years, you've shown me 3 statements. That's not sufficient. That's not sufficient documentary evidence to show the trend, specifically because it's not just between a couple of accounts. This was, under his testimony, it transferred from this account to that account to that account, all the way to the 3019 account. And there's no explanation for why that documentary trail is not there. He didn't testify that the documents were destroyed. He could have just as easily shown the whole thing.
I can't say for sure, but one explanation might be that it was precluded.
One explanation might be it was precluded, and if
it's precluded, unfortunately, the court may have worked against its own interests there, because even if the documents were properly precluded, there was enough to cause the court to have to do this work, and the court effectively took away the tools it needed to do it easily and effectively. But it doesn't get rid of the evidence about the existence of the funds in 1999.
Well, what I would say, Your Honor, is that it's their burden, husband's burden, to prove by clear and convincing evidence that that there is a tracing back to sole and separate property, and he failed to do that. This isn't the court having to decide, okay, I need to have all this information. If I don't have enough information, then I need to kick it off to a quadro or whatever. It was their burden that we start with the assumption that because the account was created during the marriage that it's community property. He has to prove by clear and convincing evidence that it wasn't. He didn't do that.
But if you have a precise number of deposits made, actually rollovers made into the account with only one withdrawal, I mean, isn't that clear and convincing?
If you
Can the court ignore that?
Well, but I think in order to come to that conclusion, you have to rely on his testimony, because the documentary evidence is not complete. So that the documents don't tell you that that's what happened. I mean, it is possible that all that money could have gone out and come back in. He could have borrowed it. We don't know what happened in the course of 20 years, and we don't know why he didn't give us all of that evidence. So I think what Your Honor is assuming is that the testimony is correct, that it was credible, and that's where the court found that the testimony of the husband wasn't sufficient, wasn't credible, and that in the case of the 3019, that he wasn't an accurate historian. He made a number of mistakes in terms of his calculations and mistakes in terms of what he said actually happened, and so that also goes to the credibility, because in that case there were even questions about whether something was a certain amount was it the result of income coming in from somewhere, or whether it was just appreciation.
Okay, let me ask you, if I could change subjects, given the time, about spousal maintenance. The court made findings about each subpart of ARS 25319A. I don't see in there, other than one conclusory statement about the ability to meet wife's needs, any conclusion based on those findings that supports an award of spousal maintenance. Can you help me?
Well, I think that what the point that Your Honor has characterized as conclusory is, I think, that the crux of the issue there, that after looking at all of and I'm not sure.
Well, the court said, wife has $700,000 in cash and can't meet her needs. That strikes me as conclusory because I have, I've done a few thousand divorces now. I don't see too many where people have $700,000 in cash, and it would seem that if we were to define that as not being able to meet your needs, we could pretty much just take 25319A out of the statute books because it's never going to be a bar. So I don't know how the court got there, and I don't see anywhere else in its findings that it supported a spousal maintenance award.
Well, I think, Your Honor, that the other thing you have to take into consideration was the standard of living of the parties.
No, you don't. This is 25319A we're talking about, not B.
Oh, A. Okay.
Yeah. The standard of living is not part of A. So I don't see an A finding that gets us to B. Or an A conclusion of law. I see findings of fact. I don't see a conclusion of law that isn't just impossible to accept that gets us from A to B.
All right. Well, I think I'm not sure. I think that the trial court's finding was sustained by the facts. I'm not sure what, but I'm not sure what the court is.
Explain to me the court's reasoning. This person has $700,000 in cash and somehow can't meet her reasonable needs. What's the thought process there? Because I'd love to get that deal myself. I just don't know how that is now how that amount of money falls below the baseline for meeting one's reasonable needs.
Well, I guess it depends on what the court's finding of reasonable needs is. I think also you're talking about that when you're talking about the $600,000 or $700,000, that's a one-time. That's not income. Okay. That's not something that's.
Well, a lot of people who don't get spousal maintenance walk away with nothing, not close to $1 million. So, how do we get? You've suggested that depends on your interpretation of needs. Lay it on me. What's your interpretation of reasonable needs under the statute that is based on the statutory language and not some impression about where we'll be if we ever get to Part B of the statute?
Well, Your Honor, I guess I would say that it depends on the context. And
let's take today's context.
Well, the context of what are wife's reasonable needs, and doesn't that depend on what her situation is?
I don't see any law that says that. Certainly nothing in the statute, and I haven't seen any case law that says that with regard to A. What I have seen is a little bit of case law that says we should give that some consideration once we're in amount and duration land under B. But for the gatekeeping function of A, I have not seen law that says, a rich person's reasonable needs are greater than a poor person's.
Counsel, just to read you 25319, 2 says lacks earning ability in the labor market that is adequate to be self-sufficient. The court said wife is part of several family businesses, although neither producing significant amounts of income, but her income over the last 10 years has averaged approximately $45,000 per year. Doesn't that finding support too that she has an earning ability that is adequate to be self-sufficient?
Well, I guess that's the question is whether, is $45,000 under the circumstances self-sufficient?
But that's not what the statute says under the circumstances. It just says lacks earning ability in the labor market that is adequate to be self-sufficient. Can she support herself in the labor market?
The court's findings were actually fairly laudatory of wife's income earning capacity. Highly skilled, employable, all sorts. I don't see it in that finding. So while Judge Payton's examining the earning capacity, I'm looking at the finding on sufficient property, and nowhere am I seeing a rationale that leads to an eligibility for spousal maintenance.
And it could be one or the other, right? Of those 5 subsections under
it's
A, it could be any one of those.
Well, that's right, Your Honor.
It is surely a disjunctive statute, and the court made careful findings, I think, to deal with that. Made findings on all 5 prongs. I just don't see a conclusion that supports the result. And it's difficult for me to imagine how somebody sitting on $700,000 plus employability plus income is unable to meet her basic needs, but just with an extra 75 grand over 3 years, now it's okay. You know, the court's 319B analysis doesn't even support its 319A analysis from what I can see.
Well, Your Honor, I understand what the court is saying there. I think that, though, as either Judge Payton or Judge Cruz said, it is disjunctive.
So which prong are you relying on? I agree it's disjunctive. You can pick any of the 5.
Are we
Well,
really
in-
talking about a situation where the court was looking at the standard of living as opposed to whether she would be able to maintain the
Well, I
standard
think
of
so.
living of the marriage?
Yes, Your Honor, I think so. And I think under 4 it says that, which is under the A analysis, the parties were married for a little over 20 years. Wife is 51 years old and capable of maintaining employment, although not at the level of her current needs. So I think that's the basis for the
So what
finding.
defines the needs? Were there any finding to support what her needs are?
Well, I think that the ultimate conclusion of the court in granting the spousal maintenance is an indication of that.
Well, I might have been able to trace the court's reasoning that way if the award hadn't been so paltry. But if what you're saying is, yeah, $1 million really isn't enough for this person's needs, then how is an extra 75 grand going to change that? What are these needs that are so extensive that they trump everybody else's needs?
Well, I'm not sure that the court said that they trumped everybody else's needs.
She has an entitlement to spousal maintenance even though she has more property than almost everybody else in the state. What makes her needs greater than everybody else in the state?
Well, I don't know, Your Honor, that you have to look at what are the needs of everybody else in the state.
No, what I look at is the language in the statute, which says absolutely nothing about lifestyle. It only talks about reasonable needs. And what I'm not seeing in the court's order is a finding of what the court meant by reasonable needs. I know how I would interpret that term. If there is some other interpretation, it would have been nice for the court to say, well, she has reasonable needs that are extensive because of a disability or ongoing expenses necessary for basic care or anything like that. But there's nothing like that. There's only a statement that she's highly skilled and employable.
Well, and in addition, that this doesn't meet her basic needs. So, I mean, yes, it's a conclusory statement, but it's. I think it's borne out by the findings, by the amounts that the court awarded.
So what are the needs? Tell me, give me a need that is exceptional here.
Well,
so I don't see it in the record of the court's findings, but I'd like to hear it from you.
Well, I don't know that I can articulate an exceptional need if that's but I'm also not sure that's what's required.
Well, articulate an expensive need then. I mean, why isn't this enough money?
Well, it's not enough money because it doesn't. It doesn't. Because she can't. Well, I guess it conflates. I guess just.
I know you're trying to avoid using the word lifestyle. Well, no, the legislature avoided using that word too. So let's stick to the language of the law. What do you have?
And ultimately, that particular factor says, had a marriage of long duration and is of an age that may preclude the possibility of gaining employment adequate to be self-sufficient. So the court said she's capable of maintaining employment at approximately $45,000 per year. So even though it said not at a level to meet her current needs, is that not adequate for her to be self-sufficient?
Well, the trial court didn't think so.
But again,
And
we're
so-
talking about two prongs here. My question remains outstanding. Go ahead and answer Judge Payton's, but my question is different.
So is your question as to one?
My question is as to sufficient property to meet reasonable needs.
Okay. Feel free to answer Judge Swan's question.
Well, Your Honor, I don't know if I have anything more to say than what I've already said on
All right.
that issue. So.
Thank you, counsel. We have gone quite over with time. Wanted to give you an opportunity to answer all of the questions. I appreciate your responses. And we have 3 minutes and 29 seconds for appellant.
Thank you, Your Honors. I did want to follow up on one question that had been asked about the prejudice that we suffer as a result of the expert being not being allowed to testify in light of the fact that we have Exhibit 29 and 30. And I think there's another reason why we're prejudiced there, and that's because we had to spend an enormous amount of time going through the Exhibit 29, going through the 300 pages plus of exhibit number 30 and eliciting that testimony, which then caused us to run out of time to be able to really fully address a lot of the other issues. So by precluding the expert who would have been able to get up there and summarize the information and provide the conclusion based upon her review of everything, it caused us to have significant time issues then at trial by having to spend an enormous amount of time. And the same thing happened with the fact that we couldn't use the demonstrative exhibits.
Alternatively, you could have disclosed them earlier.
Alternatively, had we been involved in this case from the beginning, that might have been the case.
I have no doubt.
But having not done so, we did what we could and agreed that we would only come into the case if we had had the ability to do that.
You
Even so,
inherited a tough situation, so I'm not blaming you personally, but a one-day trial in family court is pretty substantial, as you know, right? And we can argue about whether that's sound
Right.
public policy, but that is. And I wrote Volk. I am sympathetic to this, but the efficiency could have been created by your client before you got involved.
and Your Honor, if we could have submitted that expert sooner, we would do so. But in light of the fact
How many days before trial were you on the case?
the trial was approximately June 8th that the court granted our motion, and then the court set right after that the scheduling order, so it was 49 days before trial. So that's what really caused this issue, is that there was only 49 days. And again, we had asked for at least give us 60 days before you scheduled the trial. That was not granted, and it was
But with all
granted at
due
49.
respect, you had 49 days. Your client had a lot more than that.
Your Honor, and he did provide that exhibit number 30, which is I think very interesting, because one of the complaints that wife makes is, well, it only showed partial. You showed us before, you showed us the statement in the middle, and then you show us the end. And we wanted the whole 25 years of these statements. Is that what you should have been able to have? They had that document ahead of time, and they could have asked for additional information. They could have subpoenaed additional information, but they knew well in advance that there was going to be an Exhibit 29 that did the tracing, an Exhibit 30 that had the documents laid out. So when we talk about credibility, and when wife wants to say, well, the court didn't find him credible, the court had documentation and unrefuted testimony based upon Exhibits 29 and Exhibit number 30. And
Counsel, based on which rule of evidence did you offer that demonstrative evidence?
Your Honor, it wasn't necessarily under a rule of evidence other than to say that we're just using it for demonstrative purposes to aid in the witnesses being able to refresh his recollection.
All right.
Thank
All right.
you.
Thank you very much. Council, we appreciate your briefing and your arguments here today. This matter is now taken under advisement, and we will issue a written ruling in due course. And with that, we stand adjourned. Thank you.